Mr. Egan, good morning.
Good morning, Madam Chief Justice and members of the Court. May it please the Court. This matter has been reserved and reported by a single justice to the full bench on 3 discrete issues. I will address the first and third of those issues, the impoundment issue and the standards upon any remand, and use 10 minutes of our time, and Mr. Thompson will address the de facto parenthood issues and the subsumed Fifth Amendment issue and take the remaining 5 minutes of our time. This case involves the tragic plight of an 11-year-old child who lies critically injured in Bay State Medical Center.
Well, she's actually in a vegetative state, is she not?
She is in not a persistent vegetative state, but she is in a vegetative state. The footnotes in the Brophy decision indicate that in order to be in a persistent vegetative state, you need to be in that condition for 90 days. The department moved within 3 weeks to have her food and hydration terminated, which would lead to her certain death.
But by all medical opinions, she has no hope of recovery.
The medical opinion on this is split, and we have not had the opportunity to have any independent medical examination, Justice Graney. The 2 attending physicians, one of whom supports removal, and he is the chief, supports removal of the ventilator, but not food and hydration, and his associate, that physician, supports removal of both food and hydration and the ventilator. So the juvenile court was presented with a split in the medical opinion.
But the split amounts only to, with regard to the manner in which she will die.
Not so. The 211-3 petition, and we are somewhat at a disadvantage here because we're not allowed, there's no record. We weren't allowed access to any of the record because of the impoundment order. But the 211-3 petition, Mr. Schubert, who was her counsel at that time, says that the chief said that if the ventilator was removed, she could live for 20 years with appropriate nursing care. The findings don't say that. The findings say that if the ventilator is removed, she would die within a matter of months. If food and hydration were removed, she would die within a matter of weeks. We asked the question, what's the hurry? But
the statute, Chapter 119, Section 24 and 26, talk about the department having the authority to provide care. Here we're doing just the opposite. We're removing care. Does the juvenile court have jurisdiction to enter this kind of an order?
I think the juvenile court has entered this type of order previously, Justice Spina.
Was there a challenge to the jurisdiction of the
There was no challenge to the jurisdiction
So
raised.
that is not before us unless we decide it's
subject
matter jurisdiction. We did not raise the issue in our petition. That's correct.
Would you consider this typical of what the legislature, not even typical, but conceivable under what the legislature intended as a care and protection petition? Care and protection, by its definition, by its terms, is for a living person, is for someone who is in need of care and protection. And it's one thing to talk about someone who needs dental care or a doctor's appointment or an inoculation or even to give blood or take blood. Another thing to make a life-terminating decision under the aegis of a care and protection petition, which is thereby impounded in secret.
That's correct, Justice Cowan. We would not consider this to be in the nature of providing for the care and protection.
Did you ever argue that below?
We didn't because we were not allowed to participate in the hearing.
Well, you've certainly, I mean, have you argued it at any point where you have submitted any?
No, we have not, Madam Chief Justice.
I mean, it seems to me there are 2 different things here. The first is, does it, at least 2 different things. The first is, does the juvenile court have jurisdiction? And even if the juvenile court does have jurisdiction, does any impoundment which is applicable to proceedings in the juvenile court cover any and all proceedings, as opposed to certain proceedings? As I read, at least the amicus brief submitted on the part of the child, or perhaps it was on the part of the siblings, they were essentially making a privacy argument. I mean, they rest on the statute governing care and protection proceedings, but the arguments would go to the impoundment of any proceeding where you have a child in these circumstances, whether or not he or she is in the care of the department.
That's the argument made by the amicus. We think they are incorrect. The statute that the juvenile court relied on relates only to the parent protection sections of Chapter 119,
Right.
sections 1 through 37. And it only talks about the hearing being closed and the party's identity being protected. We are not advocating that the hearing be open. We're not advocating that the party's identity be released. Certainly, you can take matters much less restrictive than the juvenile court took in this case when he not only impounded the matter with regard to the general public, but he impounded it with regard to counsel. The only document we've been allowed to see in this case is his findings, and that was only after a remand by the single justice. We can't see the motion for impoundment. It wasn't
a written motion.
It
How
was
could
not a
anybody
written
see
motion.
it?
It's not in compliance with the uniform rules. His findings don't address the issues, and when it was remanded to him, he placed a burden on us absolutely contrary to the finding
Now,
of this
as
court.
I understand the relief that you are seeking here, you are not seeking any open access. The relief that you sought was a remand, in other words, to this court, to the juvenile court. You weren't seeking another court, permitting your client, as the child's de facto parent, so if there's a legal conclusion that Mr. Strickland is not the child's de facto parent, you're out entirely. So as the child's de facto parent, to litigate all issues and order the juvenile court to apply proof beyond a reasonable doubt. So as I understand it, you're saying, I want to go back, if I am the de facto parent, I want to go back to the juvenile court and to let this man alone proceed in the juvenile court under the impoundment orders of the juvenile court. Correct?
No.
Okay, well, that's what you asked for, and I'm just leading you.
Maybe it was inartfully written. I'm sure it was inartfully written, but what we were trying to ask for was a remand to the juvenile court,
Right.
agreed, with a lifting of the impoundment order.
That's not what you asked for.
Well,
I mean, you asked for lifting to vacate the impoundment order and order the juvenile court to permit your client to litigate.
Yes, a remand to the juvenile court without an impoundment order, and to recognize the standing that we have to litigate, and a very important issue here is, and for this court to address the constitutional infirmity that Troxel has created under the substituted judgment test. Very significant issue in this case is that the wrong standard was applied in the juvenile court. If you look at finding 6 and finding 10 of the conclusions of law, set forth on our brief on 44 and 45, I believe, the juvenile court judge repeated twice
Yeah, I understand.
the standard Sakowitz argument.
I understand.
And that Sakowitz argument, which equates best interest with substituted judgment, now comes into conflict with the United States Supreme Court decision in Troxel and this Court's decision in Blix.
Assuming your client is the de facto parent.
yeah,
If your client is not the de facto parent,
that's the
this
end
is
of
not
that.
there's no...
I would respectfully disagree.
Why?
He's a party to the case, number one.
He's a party to a different aspect of the case.
He is a party to the case.
No, I understand, but that's not Troxel.
Didn't the judge find that he's not a de facto parent?
The judge did find that
Okay,
he...
so if we have that finding, it has to be clearly erroneous to be reversed. Am I correct?
That's why I left it
Okay.
to Mr. Thompson
Right,
to
all right,
address.
well-
And if that finding is not clearly erroneous, he's out of the case.
I respectfully no.
Why?
Because he's a party.
But why
And
is
he
he
has
a
standing to
party?
Was a party until the judge found him not the de
He
facto
remains a
parent.
party as of today. The
party.
DSS makes some argument in their brief that there are 3 different docket sheets. One case, one number, there were motions to sever.
He's a party with no right to argue at that point.
Mr. Egan,
A
why...
passive
if he's-
party.
What's... I mean, if the... First of all, it's unclear to me why he wouldn't file a motion to dismiss. I think I can understand dismissal. If he's not a de facto parent, he has no rights or responsibilities with respect to this child. If you don't file a motion to dismiss, I assume that the department's free to file a motion to dismiss. He doesn't have a right to participate if he's got no standing to participate.
Your Honor, motions to sever were filed and denied by the trial judge. The trial judge acknowledged he has a heightened interest. That's in the trial judge's findings. The trial judge acknowledged that he has filed a separate petition for guardianship of this child, and if the trial judge's order goes forward, that petition will never be heard because the child will be dead. In addition, you have the extraordinary circumstance
Right.
here of there being no one in this case that ever argued for life. And that's a direct promise of this court in Sakowitz. There will always be someone, was supposed to be the guardian ad litem, that will argue for life. Was never done in this case.
Well, that's a separate issue with respect to your client's standing. Can you just walk me through, I understand the red light is flashing, pay no attention to it for the moment.
Thank you.
Assuming that your client is not the de facto parent, and leaving aside the particular circumstances of this case, on what basis does the Commonwealth have the right to insist that he participate in the proceedings? That's question number one. And on what basis does he have the right to insist on participating in the proceedings? Leaving aside the judge's order, I'm just assuming that you have an adult who has been living in the same household
That's correct.
as a child over whom the Commonwealth has asserted care and protection. But once that determination is made, on what basis does the Commonwealth have the right to keep him in, or does the defendant have the right to stay in?
Once the mother was dead, he was required to be notified under Section 24 of 119, because he was the person with who had custody over the child.
But at that point, if you're going to go to that point, I think that point is after the proceedings had begun, am I correct?
That is correct.
The child was no longer living with him at that point. She was in the hospital on life support. So if you're going to move to that point, you're going to move the target's going to move with you, and the child, he's no longer living with her.
I think under the statute does not make that distinction.
That's
But that's not...
You just argued that he was the guardian, the person living with her.
He was required to be notified under that section.
At the time that the proceeding began, the child was living with the mother, the adoptive mother.
Mother and the father.
Right. But, so that
Stepfather.
he wasn't the person to be notified because the mother, who was the adoptive mother, was alive, and she was notified. And at the time that you're claiming he should have been notified, after the mother died, the child was no longer living with anyone except the people in the hospital.
That's correct.
Mr. Egan, you understand that the consequences, leaving aside the unusual circumstances, I'm assuming this is a standard care and protection case. Even if I happen to be the person with whom the child is living at the time, I could be an aunt, I could be an older sister. But once there's been a factual determination, which is challenged and upheld on appeal, that the adult has no legal relationship, a de facto parent establishes a legal relationship to the child. Once that has been determined that this individual is not a parent, is not a guardian, is not a de facto parent, surely then that person has, either way, the Commonwealth has no right to insist that the person remain in the proceedings, or that person has no right to insist that he or she participate further in the proceedings. Surely that's the case.
Well, I think in the extraordinary circumstances, and you couch that question in general circumstances, that might be a very fair statement. However, you've got the extraordinary circumstances present here where no one, it's almost a collusive action. No one has argued for life.
Well, the question of whether or not the child is being appropriately protected is a different question, You are claiming, because nobody is seeking the particular relief that your client would seek, therefore he is the only appropriate person to protect her interests. And it seems to me that that's putting the cart before the horse. There are many other ways to protect a child if the court determines, for example, you have guardians ad litem, there are all kinds of other people, but it doesn't give any one particular individual.
Where do we go if the guardian ad litem has not done what he is specifically charged to do, to advocate for life, to advocate for prolonged treatment in Sakowitz, when the judge says, this order, when we all agree, this order will lead to certain death of this child, and I'm only going to stay it for 7 days? Where do we go to get the court to say that, that the U.S. Supreme Court has said the unadorned best interest test is unconstitutional, and that the substituted judgment test, this court has said, is the same as the best interest test.
I
Well,
think that, again, that's a question.
I don't think that tension is there, quite frankly.
That's the definition of this court, and it's the definition that was applied by the juvenile court, that when there is no evidence of the incompetence wishes, the best interest of the child is the rational and practical equivalent, I'm quoting now, of the substituted judgment test. Now, the substituted judgment cases fall into generally two factors.
Wait a minute, Mr. Egan. Now we really are going further over, because what's at issue here, as I understand it, is the impoundment of these proceedings, correct? So we're not getting into the...
No, we raised both issues.
We do have the resuscitate, remove the ventilator order.
That's all. We also raised that issue on appeal, that it was error. There was error below because they applied the wrong standard. They applied a standard which Troxel and Blix acknowledged, best interest, undefined, is unconstitutional. So you have, under the guise of exercising the liberty interest of this child, the state coming in and saying, well, we've got no evidence of what the child would have done, so therefore we look to the best interest of the child, and Troxel has said you can't do that. Blix has acknowledged you can't do that.
So who would we put in here? Mr. Strickland, who was charged criminally with regard to this child, in which I understand a probable cause has been found?
Probable cause has been found. It was
and
found
the charge is what? Assault and battery?
The charge is assault and battery, but not the assault and battery leading to these injuries. It's assault and battery on twice hitting the child with an open hand and once with a wand. I was not present, but I did read the transcript.
Mr. Egan, I take it that you may have raised... That you have raised a question on one side doesn't say that your client is the only person who can assert these interests. It seems to me, without going into any detail, that your client has, at very minimum, a profound conflict of interest in this case, if he is the person who is asserting the child's interests. Correct?
Respectfully, Your Honor, no more profound than the Commonwealth's conflict of interest here. If they're pushing a prosecution or they don't want to pay these bills, there's a profound conflict of interest there, and I acknowledge that there is on our side, but that's something a judge can weigh.
I don't see any finding about the Commonwealth doesn't want to pay these bills. Where is that in the record?
I do not see any finding about that, Your Honor.
Then that's sort of irrelevant, isn't it?
Because there's a...
It is irrelevant.
No one was allowed to raise the questions. No one's been allowed to even ask why the DSS made these decisions. No one's been allowed to examine the social workers. No one's been allowed to ask the DSS why they've been...
That may well be, but that does not give your client the right to do so. Mr. Egan, your time is...
I would respectfully say that without intervention by this Court, this child will die, and that when the improper standard has been applied, when it runs into Troxel, an opinion of the United States Supreme Court, and does not comport with substantive due process, when the wrong burden of proof was used as required by procedural due process, that it calls for this Court's intervention and not to simply look at it as an issue of standing. Mr.
Thank you.
Thompson.
Thank you, Mr. Egan. Mr. Thompson.
Thank you, Chief Justice Marshall, members of the Court. The reason that the juvenile court judge is ruling on de facto parent is clearly erroneous is that it was based on the wrong legal standard. The judge took a...
Are you taking that from what was on page 18 of Mr. Egan's brief, where he said that your client and the children met their burden, and the other place where he said in the same paragraph that your client did not meet his burden?
No, I'm taking it from his statement in his order saying that...
Which order, just so that I'm following with you?
In the October 28th findings at paragraph 3, in the appendix pages 22 and page 54, I believe, the two findings are expressed, and also in the transcript of the hearing at think it's at page 17 or 18.
I see the findings of fact, and I have to say I was, I don't know what the correct characterization is, but I'm looking at paragraph 5, which says that your client didn't adopt the child,
Yes.
nor is he a de facto parent. That strikes me as a conclusion of law, and I'm not quite sure what the findings are that support. That's why I asked you to be quite precise as to what his findings were.
I don't think that, he made one finding, and that is that there was, that that the stepfather did not provide the majority of the caretaking functions. He took the Yeoman's case, which involved,
Right.
which was a situation where the petitioner clearly did provide the majority of the caretaking functions, and a statement from the court to that effect, as establishing a threshold requirement, a single, what I would call a single qualifying criterion. He said, well, they didn't meet that, and that's the end of that inquiry. The case
But isn't your argument really, or shouldn't your argument be, that he placed the burden on the wrong party, that it isn't your burden to prove that the impoundment order shouldn't remain in place? It's the common, when someone seeks to have something closed to the public, it is their burden. And so therefore, it was DSS's burden.
As far as the impoundment is concerned, Justice Cowan, yes.
Yeah.
I think it is the burden on the moving party. Here, I think the burden of proof on the question of de facto parent is a little more difficult. The DSS has argued that it was our burden, but
Isn't that what the law is?
in the procedural context here, this is, the DSS got custody of this child on an emergency order on September 13th.
Right.
The 72-hour hearing really would be the occasion where the question of of the stepfather's parental standing would logically come up, and the DSS has the burden of proof at that hearing, by a preponderance of the evidence, the 72-hour hearing, to establish that the child is in need of care and protection.
Mr. Thompson, again, forgive me for interrupting, but it's there's an unusual circumstance in this case because your client has a biological relationship with one of the other children involved in the proceedings.
Yes.
Correct?
Yes, he does.
And so the fact that your client was there is not surprising because he's the biological father.
He was the biological father of the youngest child.
Correct. And at certain points, the court may proceed to sever off certain parts and not other parts. But if, to the extent that your client is seeking to have rights and responsibilities with regard to the child who's now on life support,
He does.
it seems to me that you have that burden. You may have participated in the hearing because of the other relationship, the biological relationship, but that it seems to me that it is always the burden of the adult seeking to establish that they are a de facto parent, correct? I mean, why would that not be correct?
The only reason that I think that might not necessarily be true is, like I said, this is the 72. This issue comes up at the point where it's discovered that the mother is dead. At this point, the stepfather is under the statute, he's the last adult with whom the child resided under Section 24. That's the language. It's not that that she was residing with him at the time the decision was made, but he was the last adult that she resided
But
with.
that's not going to establish de facto parentship.
No.
De facto parentship, and the difficulty here is the mother cannot speak. The mother is deceased.
Yeah. Well, and we don't stand on where the burden of proof lies. Our argument here is that the standard that was used, the legal standard that was used to decide whether he was the de facto parent, was incorrect. No one here is defending that standard. Neither the child's brief nor the DSS brief says that was the right standard. As a matter of fact,
Which standard?
the standard of that he had to be the provider of the majority of the caretaking functions of the child, or he was out. The definition of de facto parent is, our argument is not a fixed item in the law of the Commonwealth. The concept is, did he have a substantial parental relationship with this child?
That's not going to do it.
That won't do it.
Even under the more specific standard,
Even
he
under
had...
even under ENO, that won't make it. In other words, well, go ahead.
Well, that's a phrase that's used in ENO, and it's used in Yeomans, and it's used in Blixt.
And that
But-
typically comes up in the, well, Blixt is different. It typically comes up in the context where there is a biological parent who is asserting profound constitutional rights and is challenging the right of somebody else to share in the continued upbringing of the child. So we don't have a case which is really akin to this one, correct?
We don't have a case that's directly on point. That's true, but we do have the inquiry, which is, does this person have a substantial relationship with the child that should be legally recognized for some purpose? That is,
Can I ask you?
But the difficulty, I'm sorry, go ahead,
Well,
Justice Kennedy.
I was going to switch to another topic, so I'll do it. Go ahead. I'll do it after.
I have just one question. What is complicating in this case is that part of the inquiry I think a court looks at is whether the child's, we haven't used the term in quite this way, whether the child's interest, profound interest, will be served in having close parental guidance from somebody who's not a biological parent. Here, your client is insisting that whatever evidence might be introduced as to how he might have damaged this child will not come before the judge because he will assert his Fifth Amendment privilege against self-incrimination. So it seems to me that at very minimum, I don't know whether I would characterize it as a waiver, but it is clear that what we have looked at very closely is whether it is absolutely uncontested that it is in the child's best interest, and I don't use that in a statutory sense, that having the continued involvement of this particular adult who has been so important to this particular child warrants the recognition of a legal relationship. And how on earth can a court make that determination when any negative information about the parenting of your client will not be answered because of his assertion, his perfect right to assert his Fifth Amendment privilege?
well, if there had been a hearing,
Well, that's the offer of proof.
if the judge had heard evidence, first, the offer of proof was that he would invoke his privilege against self-incrimination only as to questions
Okay.
dealing with the specific topics, which were never really broached. That is, and the procedural problem is a serious one, because the inferences that can be drawn have to have some evidentiary support. If there were specific questions asked and the privilege was invoked as to those questions, then a reasonable evidentiary inference could be drawn. He invoked his privilege on this question. Logically, we can infer that he is admitting, or that the evidence would establish that he was present, that he knew this or he didn't know that. That wasn't done. That's the procedure that's recommended in Commonwealth v. Funches, which is not cited in our brief, but which is at 379 Mass 283, where in a criminal case, a prosecution witness invokes the privilege against self-incrimination. This person is still allowed to testify. Our position is that there was an adequate and substantial offer of proof that was good enough to warrant an evidentiary hearing on this issue of whether he should have the status of de facto parent, excuse me.
Mr. Thompson, maybe Justice Glenn.
Oh, I just wanted to ask you, is this criminal investigation against him still ongoing?
As far as I know...
It's obviously cannot be closed at this point with
No,
the handing
he's-
up of a simple assault and battery indictment.
He's been bound over under
He's
Chapter
been bound-
265, Section 13J.
He's been bound over to the grand jury, and I assume they're examining his complicity or lack thereof with regard to the injuries that were inflicted on this child by the mother.
I believe that was
adopted
also the
mother.
subject of the probable cause hearing. But I'd point out that the charge that was bound over under 13J requires proof that he had care and custody of the child at the time that the assault and battery was committed. So
Well,
the Commonwealth is taking the position in the criminal case that he did have care and custody of the child.
And that does not amount to de facto parenting, if that's
No, it doesn't.
It doesn't,
But
and
it's a step in that direction.
And at the time, he actually did, because the child was living in that house. So he had some control over that child.
He
But
did
the
have...
criminal proceedings that you're
but the-
talking about, Mr. Thompson, based on what Mr. Egan said, I have no information from the record, but based on what Mr. Egan said, the assault and battery that's pending against him are not the injuries that resulted in the present condition. They are earlier injuries.
That's the
So if
evidence
the
that was...
All right, so if the Commonwealth is claiming that he had care and custody at the time of the earlier injuries, that's a different time than the injuries that led to her present condition.
That's right. They're
So it's
also...
not inconsistent with their position is not inconsistent with the position they're taking here.
No, their position in the criminal case is a joint venture position. And the care and custody definition, by the way, in the statute is a parent, guardian, or any other person with equivalent supervision of or care of a child. So it is the equivalent of parent or guardian. It's a very close match. That's the language of the statute.
I
at any
understand
rate.
that's the language.
So it isn't
It's not
one-on-one,
irrelevant,
but our point is there should have been a hearing. At the hearing, the Fifth Amendment issue could have been resolved. There might have been appropriate negative inferences to be drawn. There might then have been a subsequent proceeding dealing with the possible conflict of interest that the stepfather had. But it's not necessarily a conflict of interest because it's not necessarily against the best interest of the child for her life to be continued. So these are all questions, important, factually laden questions that were short-circuited by the manner in which the case has proceeded.
Thank you, Mr. Thompson. Ms. Peel?
Good morning. My name is Virginia Peel. I'm the General Counsel of the Department of Social Services. I'm going to be splitting my time with Child's Counsel Attorney Kling. I'm going to address the issue of the error, whether there was error in the juvenile court limiting the appellant's position at the DNR hearing, and Attorney Kling's going to address the de facto parent. I just want to remind this Court, in case I'm confused about what's going on, is that the substance of the DNR order is not before this Court.
That's what I understood.
That was not in the single justice's reserve and report, and that was my understanding. And as I said in my brief, if I'm wrong about that, I would ask leave to further brief this issue. In addition, I would like to remind the Court that as to the proceeding below, where the Court limited the appellant to simply having his attorney present at the hearing, he never objected that. He had two opportunities to do it. It's in the transcript that you have before you. If you look at pages 97, begins at 97, and another hearing begins at 114, he had two opportunities to suggest that the hearing should operate otherwise, and he did not object, and therefore I believe it's been waived. Putting that aside,
Ms. Peel, could I ask you this?
Sure.
The way I heard you divide up your time, and I may have missed something, which of you is going to talk about the impoundment piece of this?
actually, neither of us were planning to talk about the impoundment.
Well, somebody's
I
gonna
certainly
have
can
to-
answer questions about that. I believe that it is so clear that if you're closing a hearing, if you're closing a court, as the legislature has done with juvenile court proceedings, particularly
Okay, it's
care
done
and
it with
protection
juvenile
proceedings.
court proceedings and care and protection, but has it done it with a matter where someone's life is going to be removed?
Well, let me address that, because I was concerned about Justice Spina's question about whether the court has jurisdiction, since I believe this court's answered that question in at least
it
three
may have
cases.
jurisdiction. It may have jurisdiction, and I think our past cases have indicated that it has. Sakowitz in custody of a minor, several of those cases. But aside from that, why should the hearing be closed?
I start from
Under
the
what
premise that what is
statute?
before
Under
the
what statute should it be closed?
What is before the court is a medical decision.
Well, it may be a medical decision, but the statute creating jurisdiction over care and protection proceedings talks about providing medical care in the context of providing care to a child. It doesn't address the broader issue of withholding care, all care from a child that will result in the child's death.
But I read this court's decisions in the custody of a minor and care and protection of Beth as saying that whether you're looking at providing treatment or withholding treatment, because both custody of a minor and care and protection of Beth were about do not resuscitate orders. That's one of the orders that's before that the juvenile court judge was considering.
Was subject matter jurisdiction argued in those cases?
I don't think anybody.
Yes.
Yes,
in custody of a
yes,
minor.
and that was why in reading those cases, and actually going back as early as custody of a minor in 78 and 79, which was the one where the parents did not want the child to undergo chemo and the hospital did. When you take those with custody of a minor in 82, which was a DNR case, and care and protection of Beth in 92, which is a DNR case, this court has been very clear that those type of medical decisions are part of the care and protection proceeding. If that's true, then proceedings are closed.
Can I back up for a minute?
Sure.
So I can get a procedural handle on this. If the DNR removed the ventilator part of the decision is not before us, which you say it is not, right?
That's correct.
The only issue being whether Mr. Strickland had authority, was a de facto parent, so that he could contest the impoundment order. That's before us?
Well, it's
Also, you can participate in the hearing.
Or
as well,
participate
as a
in the
factor.
hearing?
Participate in the hearing. I think
If-
that, I mean, his request before the single justice in his 211-3s was to get a copy of the decision. He got a copy of the decision.
that's-
I think that's now moot. I don't
Okay.
believe he has standing
So
to
if-
raise the
He
larger issue.
also did raise in his supplemental memorandum that the decision be open to the public.
But he never raised that before the lower court.
Well,
Never
Well, it was
raised that
raised
before the lower
Let's
court.
assume that Mr. Strickland's application, petition to the single justice, deals solely with access, what I'll call access. And that, in turn, is linked to him being a de facto parent. And if the judge's findings, in conclusion, that he's not a de facto parent, is sustained, we do not have to reach the resuscitation and remove the ventilator orders, do we?
No,
Because there's no one to appeal them, they're not before us, and that's the end of that.
that's correct. That would be my reading of what's before the court. That's correct, Justice Graney.
it's a sort of odd procedural question because we have before us he has at least the right to appeal the judge's conclusion of law with respect to his standing vis-à-vis this child, parental legal standing.
That's correct.
He has also raised in connection with that the impoundment proceedings, correct? And I know that you have said once it's a CNP, that's the end of it. Was there any suggestion in any of the three cases, which I think give the juvenile court jurisdiction here, to say that when you have this kind of decision, that the statute doesn't necessarily require closing of the proceedings?
I don't believe that any of those decisions answered it one way or the other. I think
And,
that...
and your answer is simply, that's what if it's a care and protection proceeding, anything that falls within the care and protection proceeding is impounded, that's it.
Well, let me take in the context, actually, of the medical decisions. I think that's why I started there. The medical decisions, when the department has custody, we normally make the medical decisions for the child. When they're extraordinary, as by regulation, DSS certainly has said, this is, antipsychotic medication is, but we also have an analysis in our regulations, which is in my brief,
Right.
at which other medical decisions may be extraordinary. Those, the department brings to the trial court and says, we're asking you to make a substituted judgment. The child who the medical decision is about has counsel, has a right to be heard at those hearings, and that hearing is really it's the authority of the court to substitute its judgment for an incompetent child who's in the agency's custody. That's why I'm saying those kinds of medical decisions are just part of the care and protection case. They're part of the juvenile court exercising authority it wouldn't normally have when the child's in DSS custody.
If a child were not the subject of C&P proceedings and parents who were completely free of the Department of Social Services sought an order from a court to apply a do not resuscitate order, I take it they would go to the probate court.
Actually, I don't believe that the law requires them to go to a court for a do not resuscitate
Well,
order.
the hospital may not honor that.
That's correct. If the hospital did not want to honor it, a court, well, I'm not sure that the juvenile court under a care and protection might not, but generally, parents would go to a probate court on
Okay,
that.
and that would be handled in open court. It would not be behind closed doors.
I think that would be discretionary with the probate court judge as to whether or not they would want to close those hearings,
Put it
given the
differently,
nature.
I think what Justice Spina is saying, that wouldn't be because of the care and protection statute, it would be because of our
That's correct.
impoundment rules and all of those.
That's correct.
Right.
Yeah.
That's correct.
There's no
But I don't read the case law as suggesting that every extraordinary medical decision that a juvenile court may be requested to provide a substituted judgment on means that it is open to the general public.
Put it this way, Ms. Peel, and it may be that the statute is, and you're relying on the statute, and you're perfectly entitled to rely on the statute, but if you take a look at the interests of society in these extraordinary matters, given that the department is recognized appropriately that this is an extraordinary matter, are the interests of this child, because she happens to be in the care of the department, which she might have been, by the way, if there wasn't a care and protection proceeding. It might have been, for example, that the district attorney the police are called, the child's mother is killed, and there's nobody to take care of the child. And
That's
she
correct.
comes into the state in that mechanism. If that were the case, let's assume that there had been no ongoing care and protection proceeding, but the department or some other entity of the government, in essence, has control of the child because there appears to be no other adult, might be no other adult withstanding to, assert any rights, those proceedings would not be closed, would they?
I'm not sure how to answer that, because generally we would go, if there's no other adult, we'd file a care and protection to get custody of the child. We could go to probate court, but again, we'd probably ask that the probate court proceedings involving those children be closed. And as a general rule, I believe, like when we were doing more termination cases in the probate court, they closed those proceedings. They were never open to the public. And so I think in matters involving the care and protection of children, whether we're in the probate court or the juvenile court, I believe the probate court is trying to apply a similar position, which is that they're not open to the general public.
The question is, for us, at least for me, the question is, should there be inquiry, namely under the normal impoundment rules? And it may well be that this child has very profound privacy interests. Or is it sufficient for us simply to say, this is a care and protection case, and that's why I raised the related case that the department is called in. It has the nomenclature care and protection, has the nomenclature care and protection, but if there's, for example, a biological aunt or whatever it is, they would be open, although subject to the impoundment orders. Do we have to ask the department to satisfy the same level of that you would have to satisfy if you seek an impoundment in a non-care and protection case?
I don't believe so. It's the department's position that the legislature intended these proceedings to be closed. There's a privacy issue related to the child and the child's best interest, and the information that has to come forward to the...
What kind of a privacy issue does the child have if she's dead? That's what you're considering here.
Well, I think what I feel like is missing here is that the child it's as if there's not due process in the lower court. And by opening it to public, that somehow there's going to be due process. There is due process in the lower court.
Did you file a written motion for impoundment with the reasons stated?
That it's the department's position that that's not needed in order to keep the proceedings and the records in the juvenile court under the care and protection statute closed. That's just the way the department operates. It's the way the juvenile court operates. It's the way we've always operated back to these early care and protection cases.
I understand. But my question is, given that there are profound, in my judgment, there are profound privacy interests here, some of which in this child and her entire medical history and everything related to her, query how much of that will get revealed if the do not resuscitate order is upheld. Second, there may be privacy interests in her siblings, for example, which are raised by the amicus. But those are the kinds of considerations that in a probate proceeding, if the department happened to be in probate court, would have to be articulated. And I take the department's position that says this was a care and protection proceeding. It didn't involve, by the way, this extreme physical abuse of this child. It was other ongoing issues between the family, primarily the mother, and the department. There was an ongoing proceeding. Those proceedings are closed. Anything that falls within those proceedings are closed. That's the beginning and that's the end of it, correct?
That's correct. And I think, I believe whether it is by practice or by rule, because I wasn't thinking about the probate court, our proceedings in the probate court are closed. As a general rule, they are closed.
But
there might be a motion hearing that's done at the bench, but as a general rule, the court closes those hearings as they do in the juvenile court.
But isn't the primary policy reason behind the closed doors of juvenile proceedings is that certain things happen in a child's younger life that they shouldn't be saddled with once they become perhaps liberated to adulthood, but just indulge me that verb. But that's not happening here. And I'm wondering, does privacy even survive death? Our causes of action for violation of privacy, I don't think, survive death, do they?
I actually didn't do the research in that issue, but the child's not dead yet. I mean, this is
Yeah, but what you're seeking is death. What
the department's seeking is a substituted judgment by the juvenile court. And so I want to just bring it back to that. It's a substituted judgment by the juvenile court. The juvenile court could have decided something totally different than he decided. And in other cases, there are extraordinary medical decisions being made by the juvenile court in exactly the same forum. Should those be open to the general public no matter what?
I know you may. It's sometimes difficult when one is so clear about what one's position is to see what the counter is.
Mm-hmm.
There may be other medical decisions that are very extraordinary, that are quite extraordinary, and may in fact result in the death of a child. For example, the risk may be very high, may result, but the intent is to prolong the life of the child, and therefore, if you would take Justice Spina's overall gloss of the statute, which is I think it is clear that one reason, or the reason why juvenile, child proceedings, sometimes in divorces, where there are issues with respect to children, are closed and impounded, is because society has recognized that having public awareness of those facts when the child is an adult can be very harmful to the child,
Mm-hmm.
The child is identified, the child goes to college, the child goes to the workplace, and the child has laid out before the child's co-students and employees all of this absolutely horrendous history that adults might have done to the child. It seems to me that there's at least a piece of this which is worthy of paying close attention to, which is that those interests are not going to be at issue if what is being ordered here, I won't say sought here, but ordered here.
I understand what you're
is
saying.
Where the child will not survive into adult life, even assuming that she can.
Okay, so I think for me then where I focus back on is the right of the child. And I think the question then I have is simply because she's in a persistent vegetative state, does she lose the right to say to the court, I don't want this open to the public?
Who has advocated?
Ms. Field, may I ask you a question?
Sure.
Judge Spina, is that all right with you?
Yeah, go ahead.
Yeah. Other than Section 58 of Chapter 119, which makes reference to youthful offenders and states that they are open to the public, is there any other section of Chapter 119 that says that the proceedings are open to the public?
Not that I'm aware of. I mean, Section 38 is very clear that care and protection proceedings are closed. Section 60, I'm going to get this wrong, Section 65, 68, says that all juvenile court proceedings are closed, and that may be why it is that the probate court closes the proceedings when we're over in probate court as well. And I hadn't sort of thought of that before. I knew our termination cases were closed. But if I can just go back to that one question, I think what particularly troubles me is the child didn't ask that these proceedings be open. In fact, very specifically argued against that. And the only person who's asking that these proceedings be open, first of all, I don't believe has standing to argue as to third parties, but he's also the person that was involved in the brutal beating of this child.
Well, but did anybody argue for the life of the child in these proceedings?
This isn't about whether this isn't about the child living. This isn't the kind of case like the original custody of a minor in 78 and 79 where someone was arguing if you give this child chemotherapy, they're going to live a long life. This is, as the court said in custody of a minor, not about a right to life. This is about the circumstances under which this person is going to be allowed to die, because it's not a question about whether she's going to.
But has anybody challenged the diagnosis and prognosis in this case?
There is no disagreement about the diagnosis and prognosis.
Well, that's not my question.
Okay.
Has anybody explored the possibility, by challenging it, that it might be erroneous?
Again, the transcript from the titled DNR hearing is not here, and I haven't read it. I don't believe that anybody did, but is it required, if you have the medical doctors who are treating this child having consistent medical opinions about her current condition?
Well,
do you really need to seek out 5 different doctors to see if they all agree?
In the absence of cross-examination, it's very easy to say that there's a unanimous view as to what will happen in this case.
You're assuming there was no cross-examination. Again, the DNR hearing itself is not before this court. And if the child and the guardian ad litem, the child's counsel and the guardian ad litem, look at the medical opinions, they are in a position, certainly the child's counsel, if they want another medical opinion, they could have brought a motion for another medical opinion. They looked at what the doctors are saying. The child's counsel at the trial level is very involved in this case, goes to the hospital, talks to the doctors. It's not as if this is a distant child's lawyer who's not involved in this child's life. And that's the person, or the guardian ad litem, who's in the best position to argue this to the court. But when you have consistent medical opinions, why do we need to find a doctor who might argue that those medical opinions were wrong? For this child, I'm not sure that I understand why this court would take that position.
Thank you.
I know my time's over, so I'll leave the rest of this to the child's counsel. Thank you.
Ms. Kling?
Good morning. Attorney Kling, and I represent the child in this action, and I'm focusing my argument on the de facto parenthood issue.
Do you agree that the judge at the trial court level applied the standard of majority of care? In other words, said because the plaintiff here didn't provide the majority of care, he is not the de facto parent?
I wouldn't say that that would necessarily be a fair reading of the way I look at the transcript. I think he cited it as one of the factors in his decision. But regardless of what you look at in the factors in Yeomans or Eno, I think that it isn't clearly erroneous.
I think, essentially, as I understand it, which would be a quite extraordinary development in the law, this man is a stepfather, correct?
Correct.
And he is saying, as a consequence of being a stepfather, as far as I can tell without a lot more, he is a de facto parent, which is a legal relationship which this court and other courts have recognized. He is making that assertion, notwithstanding the fact that the biological parent is in no position to agree or not agree. In other words, the notion of de facto parent arises classically, and in fact, as far as I'm concerned, entirely when a legal relationship, namely a biological parent, is denying access to a child, and somebody else comes in and says, I have to have a continuing relationship with this child because this child is so emotionally bonded to me. I have been so important in his or her life that it is important for my continued, as it were, future life that I have these legal rights recognized. I'm not even sure that it is appropriate to be thinking here of a de facto parent because that simply permits any adult that has had a meaningful relationship at any proceeding to come in if there's no biological parent and say, I'm the de facto parent. It seemed to me that part of what the court was doing here is to say, this is somebody who, yes, was involved in the child's life, but for whom he has, I understand Mr. Thompson's view that there hasn't been a sentence by sentence by sentence, question by question cross-examination, but where on and off the proof has been told, I will not answer any questions, and nor is it unreasonable for him not to, that have to do with any harm that he may have caused to this child. Isn't that the beginning and the end of this?
I think so, Your Honor. Clearly, in here we have a situation, you're exactly right, where the other cases really dealt with somebody trying to assert something, and there was a parent attached to it who was saying, you don't have the authority to give this person visitation rights. And I think what they're really
any
asking
kind of
for
rights or
here...
responsibilities.
I mean, that could hardly be the leverage point here. You can take this case. There's a couple of bad facts in this case, for sure. If you take those facts out of this case, clearly, Mr. Strickland has a right to claim appropriately in this very dire circumstance for a child that he has cared for the last 5 years, that he should be deemed the de facto parent.
Well, I would suggest, Your Honor,
exercise those rights.
if you look at the factors, that he doesn't meet those factors, that he doesn't meet it at all. In fact, what you look at is various factors that this Court talked about, so whether with the consent and encouragement of the legal parent, did he perform a shared caretaking functions at least as great as the legal parent, whether he shaped the child's daily routine.
But let's be practical here. Let's be practical here. He worked 60 hours a week. He supported the family. The adoptive mother stayed home and took care of the children. Of course, that's perfectly understandable. But that isn't the end of the inquiry. She was spent more hours in the day with the child. Therefore, he couldn't be a de facto parent.
Well, I think what these factors really get to, Your Honor, is that emotional connectedness. It's more than just he provided the financial support. Did this child look at this individual as a parent? And strikingly, Your Honor, one of the things that even Mr. Strickland recognized, Your Honor, is that this child, in her direct relations with him, never referred to him as dad. She was not comfortable enough to even refer to him as her father. And I
thought the evidence was that she referred to him as daddy, except she called him Jason.
What the transcript from the hearing says is that in her talking with other people, she referred to him as her father, which is understandable given this child's complicated family history. It's easier to say he's my dad than to say, this is my adoptive, this is my stepmother, father, what have you.
Did the guardian ad litem get into this question of whether he should be considered a de facto parent or not?
Your Honor, I don't know, because I don't have access to the guardian ad litem report, so I can't speak to that. I think he was charged with looking at the decision as to the DNR and not necessarily as to this issue of de facto parent.
And in fact, Mr. Strickland, I don't think, has had access to the guardian ad litem's report either, has he?
I could not speak to Mr. Strickland.
So we don't know. That's part of the problem here. We don't know.
All I can say, Your Honor, though, is that when we're looking at de facto parenthood, it's tied into what is in the best interest of this child. All of these decisions are tied into what is the best interest of this child. And here we have a child with a lot of serious injuries who is in a persistent vegetative state, who, at the very least, this particular individual, at the very least, failed to protect her, and at the very most, he's responsible for. How could it be in her best interest for this individual to be involved in the medical decision-making of this child?
That's very interesting, but that's not what the Court says. The Court says he's not a de facto parent because he didn't provide a majority of the care for the child. That's what the Court says.
That was one of the reasons it gave, correct.
Well, it's the only reason, as far as I can tell.
Are there other reasons in the judge's findings?
I think the judge also indicated that he drew a negative inference from the fact that he would fail to testify as to certain issues as well.
Absolutely.
So that was the things that he cited. It would be certainly cleaner if we had written findings. We don't.
Well, he
However,
said that in his findings. He said, this is the...
Negative
right, he drew the negative.
And that's at least in this case, a very powerful negative inference when you've already got a criminal complaint and an ongoing investigation. Because when you talk about de facto parent, you're talking about someone who is substituting for the real parent, who is nurturing and taking care of the child. You don't talk about it in terms, as it seems to me you have here, someone who has inflicted injuries on the child and has harmed that child, either directly by reason of what's charged already in the criminal complaint, may be charged further, or by passiveness in allowing the mother to do what it appears she did. That would turn the whole concept completely on its head, would it not?
Yes, it would, Your Honor. Seeing as my time is up, if there are no further questions.
Thank you, Ms. King.
Thank you.
All rise.